SJC-12813, Philip Landry v. Transworld Systems, Inc.
Mr. Schertle, good morning.
Good morning, Your Honor. My name is Brian Schertle on behalf of the defendant, appellant Transworld Systems, Inc. The issue before the court is narrow and relates to whether the lower court erred in concluding that TSI could not enforce the relevant arbitration provision. The defendant filed a motion to compel arbitration, which the court denied, concluding that the arbitration provision only applied to claims between the plaintiff renter and enterprise rental car. The court concluded that there was no clear and unmistakable evidence that the plaintiff agreed to arbitrate claims against an entity such as TSI. We ask that the court reverse and order the parties to compel arbitration. It's clear, Your Honor, when you look at the arbitration provision that the agreement includes claims against agents or representatives of enterprise. To accept the lower court's ruling and agree with the plaintiff here would require that the court read out that part of the arbitration provision.
Now the reason that for the arbitration is that there's been a claim made against the debt collector for having violated 93A, right?
Yes, Your Honor.
To do with the contract between the
Well, Your Honor, I would disagree because the arbitration
techniques that were used by the debt collector are the problem here, not the
Correct, but TSI was retained to collect what was owed to
in a
enterprise.
lawful way, presumably.
I'm sorry?
I presume it was retained to do it in a lawful way.
Absolutely, Your Honor. But the arbitration provision includes any claim arising out of or relating to that agreement under which we were trying to collect. And so to accept the argument that it doesn't include a claim that relates to the collection of the indebtedness would mean that, in fact, if enterprise were the defendant here, and that they were trying to collect what was owed to them under the agreement.
Only if they were considered to be subject to 93A. In the same way, right?
Well, Your Honor, actually, and that's an interesting part of the case, it's really not before the court, but the statute, the regulation that they're alleging was violated here does apply to creditors. There's a limitation under the Massachusetts AG regulation that creditors, such as enterprise, cannot contact a consumer more than twice in a 7-day period. So if enterprise were the defendant here under this exact statute, which they could be sued under, then it would, I suppose, be plaintiff's position that because enterprise was collecting what was owed to them, that it didn't fall within the arbitration provision.
How come you argue agency and then you're an independent contractor until you don't want to be an independent contractor?
Well, and Your Honor, the lower court pointed that out, that how can you play this game, that the contract says one thing, but now you're taking the position that you can ignore the contract. The case law is clear on that point, though, that you've got to look behind the curtain, and how the parties identify themselves is not the end of the game. You have to look at the amount of control that the principal actually has over the agent.
Does enterprise tell you how to collect the debt?
They do have certain requirements relating to how often we have to communicate, how often we have to collect, where the money's got to be remitted, and so we lay all that out.
How often they communicate to you? They don't tell you how to collect the debt.
No, they do have certain restrictions relating to how often we have to attempt to reach out and communicate with the consumer.
Do they keep those requirements consistent with Massachusetts law?
Yes. I mean, I would certainly not argue that they require that we violate the law. To the contrary, I mean, those requirements require that we comply with the law. But my point is that those factors weigh into the amount of control that they exercise over us, such that we can be deemed an agent. But there's another part of
Then why are you an independent contractor? That's puzzling.
Well, but that's how Our position is we're not. That's how we're categorized under the contract. But again, you have to look behind the curtain. You can't just simply say because they put that label on us that we in fact are.
The label you put on yourself.
Well, it's true that there's an agreement between Enterprise and TSI, which labels us an independent contractor. But setting aside that issue, which I recognize that.
It's a big set aside.
Well, but again, there's plenty of case law that talks about how you have to look behind the curtain, and the simple label that's placed on you in an agreement is not controlling. You have to look at the facts and see how much control the principal actually exercises over the company to determine whether they're an independent contractor. But setting that issue aside, what really has been ignored is that there's another part of this arbitration provision which includes representatives, and that does not have the same issue with respect to how we're labeled into the agreement. I mean, we clearly are acting as a representative for Enterprise when we're engaged in collection of this account. And again, what the lower court's decision does is it reads out completely that term of art in the agreement, reads out the fact that the agreement says that claims against Enterprise's representatives shall be subject to arbitration. And so it's our position that by accepting the plaintiff's argument here, you've made that part of the arbitration provision completely illusory.
I'm really having some
Let's
trouble.
look to the agreement. Fortunately, my eyes are good, so I know you put some part in bold, but the rest is small. I'm looking, this is a classic adhesion contract, correct? You've got to sign this, otherwise you don't rent the car.
You have other sure. I mean, if you want to rent with Enterprise, this is the terms of the
Do I have the
agreement.
option of crossing off the mandatory arbitration agreement when I sign on to Enterprise?
I don't think that that would be accepted by Enterprise if they were aware of it.
Okay, so I am a renter, and I've got a claim I got a claim here, and I look to the procedure section.
Yes.
And the procedure says you must send a notice of dispute to the owner being Enterprise, correct?
Correct.
So I've got a claim now. I've got to send a notice to the owner, and then I can't file the claim unless I attempt to resolve a dispute not with Transworld, but with the owner.
Sure. There are certain provisions.
So how am I to resolve, if I'm looking at this, why would I think that this affects anything other than the owner or persons who have a respondeat superior relationship to the owner if I have to resolve it with the owner, with Enterprise?
There are certainly provisions in here which relate to claims that are being brought against Enterprise. The gap filler here would be the AAA rules. And the fact that it doesn't specify exactly the procedures when you're dealing with a claim against a representative doesn't mean that those gaps can't be filled with the AAA rules.
Okay, so I want to sue Transworld, but I actually don't want to. I want to respect the arbitration agreement. So I'm supposed to recognize that Transworld is the representative. I'm supposed to then give notice to Enterprise, and then I have to negotiate with Enterprise according to that's what the agreement says.
Well, again, I think
You're saying I should look to below, and it says that it should be done according to the AAA's commercial arbitration rules, and I should understand from that although it says owner, meaning Enterprise, that it doesn't mean that. It means that that I should be negotiating with somebody else.
Again, Your Honor, I understand the point, but the answer is that you don't have to spell out every single step along this process, and that the fill gap here would be the AAA rules. And so to answer your question, yes, you would look to the AAA rules with respect to how the arbitration process is going to work.
Isn't the I'm sorry, Chief.
Go ahead.
Isn't the legal standard that the language that the chief just read to you has to manifest clear and unmistakable intent to benefit a third-party non-signatory?
Well, here it does, Your Honor, because...
Well, how does it, when he just went through this exercise where you have to fill in gaps and then you have to know as a consumer the AAA rules?
You're focused on just this procedure part here, which specifies the procedure with respect to arbitration of claims against enterprise. It doesn't address claims against a representative. And so, but you don't have to spell out all of those details. Here, where there's manifest, clear, and unmistakable intent to arbitrate is when you look at the arbitration provision itself, which absolutely includes claims against a representative. And again, you know, the rule here is to favor arbitration. And so that has to be taken into consideration also.
Isn't there a countervailing public policy rule as well?
I'm sorry?
That's a public policy rule, right?
Yes.
Don't we also have a public policy that favors the vigorous enforcement of 93A?
We do, Your Honor, but this is not, and it's an important point I think you're raising, this case is not going to have some sweeping impact where all consumer cases henceforth are going to be subject to arbitration. This case can and should be decided on the unique facts presented here. We've got an arbitration provision which unmistakably, very clearly includes claims against a representative.
Which has the result of barring any class action from being
It
brought.
does,
Which means that makes it pragmatically almost impossible for somebody to invest in the attorney's fees involved in trying to bring a claim because it can't be a class action. It can only be individual claims.
I understand that, Your Honor, but...
So it has enormous consequences. These debt collection companies can now invoke the arbitration agreement entered into by the entity for whom they are collecting and therefore avoid any risk of a class action and any risk of enforcement via class action.
For this arbitration provision, again, not every arbitration provision is written this way. Not every arbitration provision, in fact, this is rather unusual to have an arbitration provision which includes a representative. Most often they do not. And so it's not going to have some sweeping impact where every single 93A case now is going to be subject to arbitration and you're going to be prohibited from pursuing the claim.
Would get rewritten in order? You don't think the contracts would then get rewritten?
No, Your Honor, I don't believe that is going to happen.
Why not?
I don't believe it works like that. I don't believe
Trade
that.
association wouldn't do that for you?
I'm sorry?
Trade association wouldn't make sure
No.
that happened?
No, I don't believe that would happen. I mean, these agreements are not changed on a whim as case law changes. And look, you look at the U.S. Supreme Court decision Concepcion and cases since Concepcion has been decided. I mean, I understand the point and the concern that consumer claims now could be subject to arbitration, but that is the law. Under the FAA, that is the law. And
I've read Concepcion.
yeah, and so
so let's turn to the arbitration costs provision.
yes.
If it turns out that the arbitrator determines that the claim is frivolous, then the owner may seek reasonable attorney's fees, meaning enterprise.
Correct.
So, and that the owner will pay, so basically, if this claim is brought to an arbitrator against Transworld and the arbitrator says it is frivolous, then the payment of attorney's fees is paid to enterprise.
Again, Your Honor, it's the same point, that the fact that the agreement has some specifics that relate to a claim against enterprise and does not list exactly every step of the process when the claim is against an agent or a representative doesn't mean that you then interpret the agreement to exclude the words claims against the agent or the representative.
Yeah, but we're supposed to read it in its entirety.
You fill the gap. I'm sorry.
But I mean, you want us to say, oh, ignore these two provisions, or say, oh, AAA overcomes them.
No.
But say you want to grab the word representative and say, aha, that should tell anybody who's signing on to this agreement, because adhesion agreements, as we have said, When interpreting adhesion agreements, we seek to effectuate not the actual intent of the parties, but instead the meaning an objectively reasonable person in the non-drafting party's position would give to the language in the contract. So that's the standard we established in Nutter last year. How does this help an objectively reasonable person to understand that this type of a claim must be arbitrated?
Okay. Again, I'm not saying that you ignore these specific provisions that relate to a claim against enterprise. They're in the agreement, and to the extent the arbitration involves enterprise, they apply. What I'm saying is that when those provisions don't address a claim against another entity covered by the arbitration provision, that the gap is filled with the AAA arbitration
I'm
rules.
looking,
And so
the print is small, but I don't see anything which says where the claim is not against the owner, then attorney's fees should be paid to the representative, nor do I see anything
But the AAA
which
rules
says.
would address that. The AAA rules
So
would.
you incorporate by reference to AAA rules, and this is what's supposed to be understood by a reasonable person signing on to this agreement.
Because the agreement specifically says that it's subject to AAA rules.
And are the AAA rules attached in any way to the,
No, Your Honor, but I
supposed to
don't.
incorporate by reference to the poor sucker who's renting from Enterprise and is supposed to be assumed that they understand the AAA rules when they sign on to this agreement?
No, Your Honor, perhaps that is not a fair assumption, but the fact of the matter is it does incorporate the AAA rules, and I don't think that you're required to actually attach the AAA rules to the agreement in order to incorporate them and put the consumer on notice that the claims are going to be subject to those rules.
Okay, thank you.
Unless there's anything else, Your Honor.
Mr. Lemberg.
May it please the court, my name is Sergei Lemberg. I represent Mr. Landry. You are correct, Justice Gantz. We are in the world of small print, so small that even with my younger eyes, I can't read it. But I
don't
did
think you
find
should,
something
Justice.
that.
Really,
Chief is old.
let me help you here. Or let me at least give you the name of my optician, perhaps.
But I did find something in this small print agreement which hadn't been picked up in any briefing before, and it's right at the beginning of it. Now, let me remind the court that my brother's burden here is to show that there was clear and unmistakable intent to benefit a third party that is not named in this agreement. That is the law in the First Circuit, and that is the law in Constantino. And we go to the beginning of this agreement, the additional terms, and tiny print, but it's there. It says, renter, right at the front, page 2 of 4. Renter expressly acknowledges that renter and owner are the only parties to this agreement, notwithstanding that a reservation for vehicle may have been arranged by a third party, that a third party may pay for all or part of the rental bill, and or that a third party may negotiate certain terms of the rental, and yada, yada, yada. How do you go from there to arguing that the agreement clearly and unmistakably confers upon a third party any rights? Beats me.
What's a representative or an affiliate?
It's ambiguous. I don't know. I think a fair reading
I
of
mean,
this.
obviously, it could be an employee of Enterprise.
I think a fair reading of this is that Enterprise wants to make it as clear as possible, unambiguous, that unaffiliated third parties that are out there in the world making reservations, somehow arranging for this, are not part of this.
Well, I assume that,
And like-
I assume the language you just read means that if a company has an employee rent a car, the person who signs for the car is on the hook as opposed to Acme Corporation that sends them on the business trip, right?
I think that a fair reading of this thing is that the person that's at the counter that's wearing an Enterprise badge, well, that's a representative, right? That person, if that representative runs you over in the parking lot, and you sue them, and then Enterprise says, all right, well, interpret it broadly. But I don't even think in that scenario, under the Constantino case and the Hogan case from the First Circuit, that agent would 100% be able to enforce the agreement. Even there, they would have a hard time, because you'd say, well, geez, the nurses in Constantino, right, they were employees too. It's not like they weren't agents. They were taking care of the grandma. And
What's
they
the
couldn't
difference?
enforce their arbitration agreement because it wasn't clear as day that the arbitration agreement entered into by the grandma was meant to cover them.
Excuse me, could you tell me the difference between agent and representative as you understand it?
I think it's ambiguous.
Okay.
I think it's not clear. And I think that because of that lack of clarity, you interpret the ambiguity against the drafter. Here, the drafter is Enterprise, and you preclude.
So you're not saying an independent contractor can't be a representative, but the language in the statute, in the agreement, excuse me, is ambiguous enough that we can't necessarily say that those claims can be brought.
My position is, I think I'm with the First Circuit and Constantino.
about your,
We're in this adhesion contract world, right?
Yeah.
These are, Enterprise is one of the largest privately owned companies in the United States. 7,200 locations, God knows how many cars. They could draft this thing so that it's crystal clear what they want.
Well, even, I think you have an argument before you even get to the adhesion contract, though, what we're calling the adhesion contract. Isn't your argument that this language covers the scope of the claims?
Well, that's the next thing, and not to
Isn't that the-
beat a
is
dead
that-
horse
is
here.
that your first argument, really, that it doesn't even apply?
I think the first, the second, and the third are all strong enough, but yes, it's a scope issue. And the law is that you cannot expand who can enforce the contract by looking at the scope provisions. And that's, again, the Constantino case, but that's also the Hogan case, and there's other cases out there which speak to that.
If you're saying the ambiguities have to be construed against the drafter here would be Enterprise, right? Not Transworld Systems.
Against the purported drafter or the attempted, the entity that's attempted to enforce it.
Enterprise is not a party in this suit.
True. My brother is attempting to stand in Enterprise's shoes, and so I think it would be fair to interpret it against Transworld as well. But let me, Justice Gantz.
If you were suing Enterprise, saying that they were indeed, Transworld is indeed somebody for whom there's respondeat superior obligations of Enterprise, then you would be governed by this arbitration agreement, correct?
I think in all likelihood, yes.
So basically what you're essentially saying is however we evaluate employees or representatives, you're saying that it would be in any context in which there would be respondeat superior liability on the part of Enterprise.
I think that would be a closer case. I think if we were suing Enterprise here on a respondeat superior, that would be a closer case. That would be nurses in a nursing home. That would be harder. I think we still win on that, but I think it's hard. We still win as against Transworld on this because it's not clear and unmistakable that Transworld was intended to be benefited by the contract. But we're not in that world. I think we're in a
I'm
far
saying that
removed
if you were to have
world.
sued Enterprise and say that Enterprise was responsible for the collection tactics of Transworld, then you may be within the
I mean, I
arbitration.
think it's conceivable in that scenario. It's a closer case, as I said. Now, again, I'm beating a dead horse, but the contract between Enterprise and
You
Transworld.
could get a better metaphor.
Their contract twice in two different places on page 47 and 56 of the appendix. establishes that that Enterprise wants nothing whatsoever to do with anything that Transworld is doing out there in the world to collect this bill.
If you were suing the debt collector based on the provision itself, wouldn't you have a problem? I mean, if the lawsuit were based on the contract directly, if it were, you owe me money, or, and the debtor's suing you, and they've stepped in the shoes of Enterprise to collect the money, and you're saying, no, I was owed a refund under that contract, and wouldn't that have to go to arbitration?
We would be in the equitable estoppel world.
Right,
I
so
think,
Machado would trigger you into arbitration
I
there.
think that
So it's
would-
really Justice Lang's first question. This has nothing to do with this contract, right? Because this thing is all, whatever the contract says, this is about making more than 2 phone calls in a week, right? It has no, just because you're making those calls because of the contract.
To be completely frank, I think it would be an overstatement to say it has nothing to do with it. It would not meet the.
Under some but-for causation, but it doesn't arise out of the
Right.
contract. It arises out of the alleged bad 93A violation of the
Right.
debt collector.
Right.
Isn't that, we got a non-signatory trying to enforce an arbitration provision for something that is about, that isn't based on the contract. It's a multiple call. Isn't this case easy? Don't you win that way, rather than trying to find that they're not a representative and other things, which seems really difficult?
Well, it may be why the appellant, having raised that theory of equitable estoppel below, dropped it on appeal here and didn't raise it, because I am surmising, but they perhaps recognized that they cannot establish that the claim and the contract were inextricably intertwined under the equitable estoppel case, such that would enable them to enforce their arbitration agreement. Unless the court has any questions, I am pretty much done.
Thank you.
Thank you.